here live from Houston, Texas. Every Tuesday at 5 p.m. Central Time, Reddy Neumann brings in the live updates about the immigration. Along with me today is my business partner, Rebecca Chen. Rebecca, what do we have to discuss today?
Sure. So today we're going to go over consulate appointments for the most part.
So consulates are giving appointment right now?
For the most part, only emergency appointments for the in-person interviews, but we will discuss some other ways that you may be able to renew an existing visa through the Dropbox method.
Can you explain the Dropbox, Rebecca, how the Dropbox work? Is it available everywhere in the consulate?
No, so these are only available at consulates in India. It's known as the interview waiver program, commonly known as the Dropbox method of renewing an existing visa that you have previously received in your passport. So the website for the Indian consulate does have the eligibility requirements. Some of them are that you have a previous US visa in the same visa class that you are renewing in. Your most recent visa was issued in India after 2008, and your prior visa wasn't annotated with any issues like clearance received or department authorization. So if you meet all those requirements that are listed on the website for the visa interview waiver, this is actually, the Dropbox is continuing. It looks like the consulates, the State Department is encouraging use of the Dropbox if you are eligible as a way to renew the visa in order to reduce the amount of in-person appointments that people are trying to appear at the consulates because of the enormous backlog. They actually expanded the eligibility requirements slightly, so definitely they are encouraging people to apply through the Dropbox in India to renew a visa if you are eligible.
Rebecca, with regards to the emergency requirements, I've only seen that they've been a little bit liberal on the emergency appointments, though. Especially if there is any health reason, we have noticed that they've been very liberal in expanding the emergency requirement. The appointments in the U.S. consulates in India at this point of time shows to be that they are available in February of 2020, nothing before that. So, so if you are contemplating to go to India, or if you're already in India, if you can't get an emergency appointment, I want you to book the appointment in February. You won't lose the opportunity of it, because if you keep on waiting, maybe you'll go until June of 2021. That's one thing. Second thing that is that for the student visa, though, they are kind of opening up some of the slots in the consulates if you're applying for the student visa. They did it in the month of August and a little bit in the September, but if any student person is there, they may want to actually, they can take an appointment at this point of time. Rebecca, what are you expecting in the visa bulletin in October 2000? As we already know that approximately around, it seems that about 110,000 green cards for the family-based immigration are going to move into the for the employment-based. Mm-hmm. Where did you get this information that the family-based is going to move into the employment-based, the unused family-based? Is it official? Because nowhere in the USCIS or anywhere it's been published.
Right, so that is a statement from the State Department, from the visa chief, the chief of the visa section of the State Department, which is in charge of publishing the monthly visa bulletin. A man named Charlie Oppenheim, who has been in this position for several years. He updates the American Immigration Lawyers Association on an almost monthly basis concerning his, concerning basically, the movement in the most recently published bulletin, his predictions for upcoming visa bulletins. And so Mr. Oppenheim has confirmed that due to the executive orders that have been in place since April and the subsequent reduction in the family-based immigrant visas that can be issued this year, there will be a number of unused family-based green cards for this fiscal year. October 2020 is the start of the government's new fiscal year, and it's been confirmed that those unused family-based green cards will spill over into the employment-based category for next year. So we do anticipate forward movement in some categories in October. Every year in October is the year when, the month when the visa bulletin is most likely to see forward movement because it's a new fiscal year. As far as EB3 for all other categories, basically countries that are not India, China, Mexico, the Philippines, it's likely that that category may become current, but Rahul, what do you think about movement for India EB dates?
EB3 or EB4?
Any of them, EB1, 2?
Now, I'm expecting the EB1 definitely to move forward. I'm not sure if it's going to be current in October, but it may become current for Indian nationals also in the entire year, that is starting from October 1st to September 30th. Will it be current on October 1st? I don't know. We will come to know about the visa bulletin probably in 1 week time, but I'm not expecting that the movement will be very fast in EB1, EB2 or EB3. I'm thinking that they will do a gradual movement of the EB1, EB2 and EB3. Although my business partner Reddy Neumann disagrees with me in the last week discussion that we had, because she thinks that if they would not advance very far in the month of October, they have to give the green cards in the year. There is a lot of time that it takes for them to grant the green cards. She estimates that the things should move forward very fast in the first month, which is October. But I have a difference of opinion on that, though. As Rebecca was pointing out, the rest of the world, that means not Indians and Chinese nationals, should be current for EB3 pretty soon. Maybe in October, I'm expecting, maybe in November, in 2 to 3 months, it should be current. But for the Indian nationals, though, I'm expecting EB3 to move more forward than EB2.
Really?
Right. The reason I'm expecting EB3 to move forward more than EB2, it's already actually, EB3 is more advanced right now than EB2 for Indian nationals and also for Chinese nationals. Why do I expect EB3 to move forward is that the number of people who are waiting for the green card in EB3 seems to be very less. How can I tell it? We don't have any official figures from the government, but we do have our own database. We look into how many people have EB3 approved, how many people have EB2 approved, and the proportion is completely disproportionate. I would say that more than 90% of the people that are waiting in our office for the priority date to become current are of EB2. Less than 10% of the people that have filed labor certification with our office who are waiting for the green card are under EB3. Now that's a very disproportionate. Now, it may not sound true in all the other law firms and companies though, but I would say that because I'm also in the community, Indian community, I see that EB2 waiting is definitely high. And you can just speak with your next door neighbor and ask him, hey, if the guy's an Indian waiting for the green card, are you EB2 and EB3? I mean, most probably you will get the answer EB2. That's the reason why I'm expecting that EB3 of India to advance a little bit further than that of the EB2. We have published a YouTube and Facebook presentation on how to downgrade from EB2 to EB3 without filing a labor certification. In other words, if the EB2 is not current for you, if the EB3 is current for you, you can file an I-140 and adjustment of status immediately. Please go back 2 weeks, 3 weeks back video that we presented. You can get the information and try to ascertain if you fit into that category. Most of the people will fit into the category of EB2 to EB3 without going and filing a prom labor. All you need to do is that your employer has to file an I-140. You can file the 484 adjustment of status application at the same time. So that's what I'm thinking about the October visa bulletin. Any other things you're thinking? Rebecca?
For the October visa bulletin, yeah, it'll remain to be seen. We're expecting it to be published any day now. Definitely, once it is published, it will probably be another couple of days when USCIS publishes their announcement on which dates they will accept adjustment of status filings for, the filing dates chart or the final action dates chart.
What's the difference between filing dates and final action dates?
Yeah, typically the filing dates chart, which is identified as Chart B on the visa bulletin, is usually farther ahead in priority date movement. That's usually the chart where the State Department kind of sets their dates depending on their anticipated caseload for the year or for the month, or it's based on different projections that they have. USCIS, in accepting I-485 adjustment of status applications, is not obligated to accept filings based on that farther advanced Chart B. They can choose each month whether they are going to go by Chart A, which is the final action dates chart, or Chart B. I would say historically, USCIS has gone by the final action dates chart, Chart A, but each month they publish their own announcement, usually a couple days after. So the individuals who will be actually able to file in October their adjustment of status application will need to wait for possibly that USCIS announcement also.
Rebecca, increase in the fees, increase in the fees is going up on October 2nd. Last week Emily said there's a lot of increase in the adjustment of status fees, but when I look into the statement though, the filing fees went down. Which is truthful, immigration or Emily?
Yeah, so Emily, definitely. So it is kind of misleading if you look only at the I-485 filing fee change from October 1st to October 2nd. It does look like the filing fee for an I-485 application on its own is decreasing, and it is for the I-485 application on its own. However, the reason why we are saying fees are actually going up for an AO adjustment of status filing is that the entire adjustment of status package is not just the I-485 form. It typically also includes the I-765 and I-131 applications for an EAD AP card. And that is usually, it's technically optional, but most people always apply for the EAD AP when they file their I-485, because that's one of the main benefits of being able to file adjustment of status, is to get an EAD card and an AP card that allows you to work and travel without having to rely on a non-immigrant visa. The fees for those two applications, the EAD and AP, are increasing. Pre-October 2nd, there is no fee for those applications if they are filed concurrently with an I-485 application. For any applications postmarked on or after October 2nd, the combined filing fees for the EAD AP will be, I believe, $1,140. So it's basically over $1,000 more per applicant to get an EAD AP, depending on whether your application is postmarked on or before October 2nd. So that is why we are saying that fees are increasing.
Rebecca, the statement of the USCIS says that the fees has been increased only by 20%. What do you think of both on the H-1Bs though? Do you think overall it's 20%, or what is this extra $4,000 that they're buzzing around? Yeah,
technically the base filing fee for an I-129 application is only increasing by about 20%, from $460 to $555, about a $100 difference. However, for any companies that are above the 50% threshold of total H-1B workers among their U.S. workforce, as they know, they have had to submit an additional filing fee of $4,000 for, up until now, new and transfer applications. For any new or transferred over H-1B application, if the company is big enough and has enough H-1B workers, they've had to submit an additional $4,000 filing fee only when the employee comes to the company for the first time, when they're changing to H-1B or transferring over. Starting in October, those $4,000 fees will be required for all H-1B applications that companies that meet that threshold are filing. Any extensions, amendments, transfers, those will all require the additional $4,000 fee.
Rebecca, now the Trump administration seems to be at the last end of at least the first term of it, which is going to end in January of 2021. Of course, new administration, maybe the same president will come in or the new president come in. We can't speculate on that, but are you expecting any spectacular changes in the last 2-3 months of this administration, the first set of the administration of the Trump?
Yeah, so we already have indications that the administration is kind of pulling out all the stops to try to get through any changes that they've been trying to make or planning to make in the employment-based immigration category, basically, before the election and before a possible administration change. So last week in our video, we did talk about 2 of those regulations, regulatory proposals regarding the definitions of specialty occupation and employer-employee relationship. As of last Friday, there have been additional developments in other areas. One rule that was actually, the proposed rule that was published concerns biometrics for anyone who files almost any type of immigration benefit.
Wow.
So,
just like the way H4 have biometrics, everybody, you mean to say H1s, L1s, O1s, P1s, Q1s, everybody has to do biometrics now?
yes, according to this proposed rule, if it is.
What about the premium processing though?
Yeah, so we don't know. Obviously, premium processing has not been possible anymore since March 2019 as a result of the biometrics requirement for
You mean to say for the H4 EAD,
right.
They were not adjudicating. But now we do have a premium processing for H1B. If they introduce the biometrics, how is that going to work out?
Exactly, yeah, so that is a major issue that, that needs to be addressed for this proposed rule. In addition, the range of biometrics that the government is proposing to collect is much more expansive than the current fingerprint and photo that they normally take. They're proposing to take a palm print, a voice imprint, DNA, a signature, presumably.
I don't think so that the murder suspects get all these things.
Yeah.
Why are we getting the immigrants getting these honor?
So it's not actually just immigrants. It includes U.S. citizens who petition on behalf of immigrants. So I would assume the U.S. citizen family members who are petitioning for their immediate relatives would also have to give biometrics under this rule. So this rule the proposal was published Friday, September 11th. It is under a 30-day comment period until October 13th. We would strongly encourage that anyone who files visa applications, companies who file on behalf of their employees, anyone who files on behalf of relatives, submit comments to this rule. It's really unnecessary for them to be collecting this much data. It really goes beyond the scope of what is necessary, and it's going to create an enormous logistical backlog, as we've already seen for biometrics requirements just for I-539 applications.
So they are proposing to collect the DNA, they're proposing to do voice, eye retina, fingerprints, photographs, and that every time they file any H-1B extension. What about amendment? They need to do it for amendment too?
Presumably, if this rule goes into effect.
So when would the rule go into effect?
So it's under a notice and comment period of 30 days. After the comments are all submitted after October 13th, the government, DHS, can take some time to review the comments, possibly make changes before publishing the final rule. So we don't know how long they may take to actually review those comments before publishing the final rule. We do know, though, that obviously the administration is trying to push through as much as they can while they are before the election, before January. So, yeah. So.
Rebecca, I've been hearing a rumor that for the F1 visa students, when they enter into the United States, they get a duration of status. In other words, as long as they're maintaining their status, they can stay in United States without any problem. They don't have to go to the immigration every time. So for example, if I come to study in University of Texas, and after first semester, now I want to move to a different university, I just change the university, change the civil system, and go to another university. And after I complete my education, then I file for my OPT, and if I'm eligible for STEM extension, then I file for the STEM extension. If they take the duration of status, they give it just like the way the H-1Bs do. Does this mean that every time I change the university, every time I file for the OPT, every time I file for the STEM extension, I have to go to the immigration and get not only 765 approved, but also get an I-539 filed right now?
Yeah, so this is another regulatory change that we know has been on the regulatory agenda for a couple of years, that the government has been wanting to change F1 students from their I-94 saying D/S duration of status to having a concrete end date. So like you said, if they do make that change, F1 students will have to apply for a new,
I-539 every time they file a EAD application, STEM extension.
Yeah.
And then in that I-539, you said I have to go to the DNA, biometrics and everything. This is going to be a nightmare. USCIS is already bankrupt with this government. What are they trying to do here?
Well, yeah, obviously the administration's motives concerning employment-based immigrations have been, they've made no mystery out of their position on it. So that rule for the F1 duration of stay, the proposal has not yet been published. I believe it, as of last Friday, again, it has cleared the OMB. So we'll also be on the lookout for that proposed rule to be published. It should be published also with a period for notice and comment to solicit comments from the public. So once that proposal comes out, we would definitely also recommend that people submit comments along these lines of, the way it will prevent students from being able to transfer schools, from getting the work authorization that they are allowed to get as part of their F1 student visa.
Rebecca, as a compromise to the litigation filed by the consulting companies, USCIS has came down and then said that the employer-employee relationship, they backed off from the 2010 memo and also February 2018 memo. Now, are there any proposed regulations that will reverse this one? Are there anything that is coming out, or regulations on the H-1B specialty occupation?
Yeah, so we've known for a while that DHS has wanted to publish regulations changing the definition or revising the definition of specialty occupation and employer-employee relationship, which are two of the main issues in a lot of visa processing, including H-1Bs. So we do know, as we've discussed last week, DHS is planning to implement that revised definition as an interim final rule. It has not yet been published, so we don't know exactly what the content is. We can guess, as since we know what the administration's stance is on H-1B visas and visa holders, that it's going to be more restrictive, a higher threshold for meeting the definition of specialty occupation, restricting the definition of employer-employee relationship. And if it's published as an interim final rule, it basically goes into effect without notice and comment period, without a period.
How come? The rest of the things, the DNAs and all those things are going to the notice and comment, where you said people to comment, and this one you're telling they can't?
If they publish it as an interim final rule, that's right. The comments are taken after the rule goes into effect. It basically goes into effect first. The threshold for the government issuing an interim final rule, something that goes into effect right away, is pretty high. Courts have required quite a bit from the government when they try to publish a rule this way through the interim final rulemaking. So it's very likely that it will get tied up in court litigation as soon as it's published, but the administration is likely also pushing this through as an interim final rule also because it's an election year.
Let's go to the questions, Rebecca. A lot of questions are coming from YouTube and Facebook with regards to can I join the EAD litigation if my biometrics are not done? Can you join the court litigation? Yes, you can be part of the court litigation, and if you're interested in, drop an email at info@rnlawgroup.com. We do have a special conference call that is conducted every day at 11 o'clock. Every single working day we do conduct a conference call for the H4 EAD delays only. That conference call is only for H4 EADs. Question from Amu from YouTube is, my H1B transfer is approved. Can I go for stamping in Mexico? Amu, the consulates right now are not fully open right now, but if they do open it and they give an appointment, yes, you can go to Mexico, US consulates in Mexico, and get the approval there. Amu also has a question, if the priority date is current, I'm in India, can I file the 485 application while in India? No. 485 application can only be, 485 also called as adjustment of status, can only be filed while you are in United States. It cannot be filed when you are outside the country. Prabhakar from YouTube has this question, I have applied for PERM in July 2020. When can I expect the adjudication of the PERM application? PERM applications are taking anywhere between 4 to 6 months at this point of time. So since you filed in July, August, September, October, November, somewhere between November and January, you should be getting the labor certification adjudicated.
Viral is asking, can an H-1B holder receive passive income in the form of a 1099? I would be very careful about any income received through a 1099 if you are on H-1B status. So H-1B visa holders can only be employed by the company that has sponsored their I-129 petition, that has their H-1B visa, the company or companies. You could work for more than one H-1B employer at the same time if they filed a concurrent employment for you. What you cannot do is work for an H-1B employer and work for another individual or company on the side that pays you in the form of a 1099, even if they are not giving you benefits, even if it's just contract work. That is not allowed for H-1B visa holders. I would definitely consult with an attorney to make sure that any income that you're receiving is authorized by your visa status.
Syed has this question. People have questions on the stamping. Syed from Facebook and also Nasir from YouTube has a question. Are they the visa stamping was scheduled before? Are they conducting the interviews? No, Nasir from YouTube. They are actually they are canceling the appointment and requesting you to make another appointment right now. The only appointments what they are giving right now are emergency appointment where there is a dire necessity for that person to come into United States. Syed has this question from Facebook. Can he go for India now for visa stamping? He is on H-1B here. The presidential proclamation is not applicable because you're already in India, in USA on June 24th, which is past 2 months. You're here. So you can go, but the only problem is it emergency for you to come back from your country? Unless it's an emergency, they're not allowing you to get the visa because of the COVID pandemic.
BJ from Facebook is asking if his wife will be able to travel using an existing H-4 visa stamp, even though it sounds like while she has been in India, he is in the US and has transferred his H-1B visa from company A to company B. So yes, Vijay, your wife can use her existing H-4 visa. If it is not expired, she can use it to travel into the US. The H-4 visa isn't company specific the way the H-1B visa is. Actually, even you, if you have a valid H-1B visa in the name of your previous company, company A, as long as it is not expired, you can still use it as well to travel.
Panjwani from Facebook has this question. Any updates on the H4 and H4 EAD premium processing? This has been rotating around because of a bill that was passed in the House, but that bill was passed only one-sided. It was not passed by it did not have consent of both the parties. It was passed in the House of Representatives that has this H4 premium processing and H4 EAD premium processing. It is not expected to go through the Senate. It is not expected to be signed by the President. So please do not have any hope on the bill that has been passed. There are a lot of such bills that get passed that never go anywhere. This is one of it, and we do not have any hope of this going forward anymore.
Irene is asking if she will be able to get an emergency appointment at a consulate because she's a teacher, which is considered an essential worker. It sounds like her H-1B was probably approved in the CAP subject lottery this year, and I assume that she's outside the U.S. trying to get a visa appointment. It really depends on the consulate. We have heard very different things from different consulates in different countries. Even within Canada, sometimes there is a huge difference between a certain consulate accepting emergency appointments. Some of them won't take anything for 90 to 120 days. We've had clients try at consulates in Mexico who have been able to schedule appointments in August, only to have them canceled by the consulate, rescheduled for September, canceled again, rescheduled for November. Even for emergency situations, the process and the conditions under which the consulate will accept or issue an emergency appointment seem to be very different and based on each consulate, on the local health situation, on their backlog. So I would definitely try. If you are classified as an essential worker, I would definitely give it a try. But just be prepared to possibly click around a few different consulates' websites to try to find the earliest availability.
A question from Cam Corder TV from YouTube has that, are they scheduling the 485, employment-based 485 interviews, adjustment of status interviews? Yes, they are, but they are very, very, very slow in scheduling the 485 interviews because there is a limited number of people that are allowed in there, and a lot of the officers are not working. Not coming to the office, so it's very backlogged though. Mr. Bhattacharji from Facebook has this question. Is the 240-day extension of H-1B, is it on the day the H-1B has been filed or on the day the I-94 expires? The 240-day rule is not on the day it's been filed, but it's on the day the I-94 expires. It's when the I-94 expires, definitely not on the day you filed it. Grishma Bhatia has this question from Facebook. Is there a proposed rule to recertify labor certification after every 3 years? At this point of time, it is there in the background of the the Trump administration that they intend to do it. But did they publish anything? Did they did any movement on that to get the labor certification I-140 approved every 3 years? Ms. Bhatia, we don't see that they have done anything at this point of time. It's there. They did. It was there in either the tweets of the Trump administration or probably one of the proposals that they have, but they didn't officially give any information on that to us. It's just unofficial information has been given to us on that. At this point of time, no, you don't need recertification, but who knows, this administration can change the things pretty quickly.
Amarnath from Facebook is asking if he can transfer his H-1B after October 1st. So it sounds like his H-1B was approved as a CAP subject application, and if he has not worked for the company that filed that CAP subject application, can he have a transfer filed by a different employer? For the most part, as long as the transfer is filed after October 1st, that should be fine. Even if you have not worked for Company A, the company that filed your H-1B in the lottery, if you were terminated by them, for example, your 60-day grace period would start in October when your H-1B period starts, and so another company could file transfer for you within that 60-day period.
Surani has this question, or a solution that he's offering is, 150 from YouTube, Surin, 150 years wait time is illogical. I mean, agreed, Surin. No, how can any person disagree with you on that? 150 years waiting period is definitely illogical. Can we file a case on it? Well, not all injustice is done. We can go to the court. This is done by the Congress, which is the parliament. So we do not, I mean, if we go to the court, there is very, very less chance that we may get anything from the court, though, because the administration, the legislation is capped by the parliament, the amount of green cards is capped by the parliament, we cannot. However, Surendra, there is one possibility that, which may be considered, is that discrimination based on the national origin. That could be one of the grounds that can be fought. Even though it was beaten many times for the immigration cases, though, that could be one thing that can be fought on, discrimination based on the national origin. That may be retried again. That would be best hope, I would say, to go for the court litigation. But here the problem with these kind of things is this will go all the way to Supreme Court. This will be a lot of expensive thing, and it's going to cost a lot of money. It's going to take a lot of time. Yes, but that's something that can be thought about. If some people form an organization and they want to come us and give anything information, we are willing to give it. But at this point of time, to leave the office that we have and go to that litigation thing for the based on the per country discrimination, based on the national origin discrimination, is a good. We can't do it. But if anybody, you guys want to organize some things, we would like to speak with you guys on that.
Lokesh from Facebook is asking if it is going to be a problem if he discontinues his degree program, a second master's or a PhD, once his H-1B is approved. Technically, no. If you're in F1 status pursuing a degree program and your H-1B change of status gets approved, then your status changes from F1 to H-1B on October 1st, for example, if it was a CAP subject application. You don't really have a choice about your status changing. You could always continue your degree program alongside your H-1B employment. It's not a violation of your H-1B status to continue studying, but whether you can continue doing both as a time management issue is, a personal decision. Immigration can't really penalize you for stopping your degree program. I would, the only kind of caveat is if you were pursuing a second master's or another degree program using CPT, that kind of brings up a whole other host of issues that could affect your maintenance of status for F1 purposes, which could affect your ability to change your status to get H-1B visa stamping in the future. If that is your situation, I would consult with an attorney.
Question that came is that on a 485 EAD, can a person work for two employers? If you are the main person, that means if you're not a dependent, you're the main person, I would request that you contact a lawyer before you take up the second job. But if you are the derivatory beneficiary, that means there is a main applicant and you're a derivatory beneficiary though. Yes, you can work for multiple jobs. You don't have to, you're clean to work for multiple jobs. Absolutely no problem. Surinder Parnayam from YouTube is there any specific path for nurses and therapists from India to get the green card, or same path and time as H-1B? Well, one problem with the nurses is that the H-1B requires a bachelor's degree as a specific requirement, and nurses, normal conditions, require only an associate degree. So they may not be easily qualifying for H-1B. There are some exceptions to nurses, where there are exceptions about 500 visas to be given to the non-profit organizations for nurses. There are exceptions. So in general, the path seems to be the same. They have to come on a non-immigrant visa and apply for the green card. There is an exception for the green card, is that they don't have to go through the PERM labor certification. The nurses and the physical therapist, but not other therapists though. the nurses, registered nurses, and physical therapists are exempt from the perm labor certification. According to the law, there is already a shortage of nurses and physical therapists in the United States. That's why we don't have to prove every time that there is a shortage of the nurses and physical therapists. Now, that exemption is not available for a speech and occupational therapist, but it's available only for physical therapists.
Cristobal from Facebook has a good question. She asks if her H-1B extension gets denied, but her priority date becomes current in October and she's able to submit her I-485 application. Will submitting that I-485 application basically grant her a period of authorized stay, even if her H-1B gets denied? So it depends a lot on when your previous H-1B I-94 was expired. If it expired in January and the H-1B extension has been pending since then and it gets denied, even if you have an I-485 filed in October, that could be a problem, because to file your I-485 application, you can't have more than 180 days out of status time. This is for an employment-based I-485 application. So assuming it's based on an employment-based category, you can't have more than 180 days out of status time at the time your I-485 application is submitted. And if your H-1B is denied in November, when your I-94 expired in January, your out of status time dates back to January, and that could be a problem for your I-485. If your current H-1B I-94 has not yet expired, if it doesn't expire until the end of this year and your company has just filed an H-1B extension proactively, and then it gets denied in November, if you filed an I-485 application in October, then that's not a problem at all. Your I-485 was filed while your I-94 was still valid, and a denied extension won't have any effect on the I-485, and you could continue as just an adjustment of status applicant. You don't technically need the H-1B to be extended or renewed in order to continue at a period of authorized stay. I would definitely check with an attorney to make sure you're not getting close to that 180 days.
Justin from YouTube, Rajiv from YouTube Facebook has this question. Can a H-4 do the drop box in India right now? Yes, if they're eligible for it, drop box is open, please go ahead and do it. A question that came is, if the person filed a EAD and they leave the country and they come back, the I-94 has changed, will it cause any problem whatsoever at all for the EAD? No, it will not cause any problem. You are leaving the country and you're coming back into the country will not cause any problem for you in getting the EAD extension under the H-4 EAD. Under the H-4 EAD, please note down. Mohammed from Facebook has this question. Can a B1, B2 can file 485? He's in USA, he has a previous I-140 approved under EB2 category and it is correct. Yes, you can file the adjustment of status while you're on B1, B2. They will look into closely the intention of you at the time when you entered in B1, B2. If your intention at the time was just to come and visit in United States, and then later on you said, well, 485 is current, the I-1, the prior date is current, let me file the adjustment of status. That's perfectly okay. You can do. You can file the adjustment of status here. Absolutely not a problem.
Amulia from Facebook is asking what happens if she is on an H-4 working based on an EAD and her H-1B change of status gets approved. Can she go back and continue working on the H-4 EAD? So if your H-1B change of status is approved, then your status automatically changes from H-4 to H-1B on the effective date on that I-797 approval notice. There's an I-94 attached to that approval notice that changes your status automatically as of that date. So if that happens, you will need to work for that H-1B employer in order to maintain status if you're not already working for that employer. If you want to go back and use the H-4 EAD, you'll have to change your status back to H-4 by either filing a change of status application using an I-539, which as we have discussed, can take months. The faster way would be to depart the U.S. and come back in using your H-4 visa stamp if you have a valid visa stamp that is not expired.
A lot of questions are coming with regards to whether I can work from India on H-1B, H-4, and different visas, though. Here is the answer, though. I'm assuming you're an Indian national. If you're an Indian national, if you're working in India, you don't have any problem. Now, can you work in India for an American company? The answer is yes, you can. Believe me, you don't even need a H-1B. You don't need any work permit for you to stay in India and work for American company. Reddy Neumann PC employs some people who are working in the US company, but they're actually sitting in India. They don't have any work permit. And we ourselves are employing people from outside the country without any employment authorization. It's perfectly legal. Now, the question that pops up is, what about the payroll? That you need to check with the CPA how they want to handle the payroll situation. The second problem that pops up is that if you are in a H-1B and you are in India or any other country for a long period of time and you're trying to come back, though, you may be asked some tough questions at the consulate. Hey, you've been outside the country for more than 6 months. Did you still have the job or not? I want you to have clear documentation that you still have a job. I want to have a fresh dated letter from your company saying that you still have a job. So if you have all those things, you shouldn't have much problem in entering into the United States. But as far as working from India is concerned, though, if you're an Indian national, you can work from India. The governments at this point of time do not recognize cyberspace as a space. They only recognize where your butt sits. Are you authorized to work in that particular country or not? Since you're an Indian national, you're in India sitting down, you can work, absolutely not a problem.
Misbah from Facebook is asking if he changes his status from L1B to L1A, what happens to his priority date, which is in 2017. So it should not affect your priority date retention, moving from L1B to L1A or a different non-immigrant status, even if you move to H-1B, as long as your I-140 remained approved for 180 days, you can retain that original 2017 priority date and port it to a new application. If you're moving from L1B to L1A, you're likely with the same company, so it probably isn't necessary for you to port anything unless you're trying to file something from EB2 or 3 to EB1, possibly. If that's the case, then you can port your priority date from your approved EB2 or EB3 application to an approved EB1 application if you qualify as a multinational executive or manager.
My company B is acquired by company A. Do I need an I-140 amendment? Yes, you need an amendment for the I-140. There are cases where the POM also need to be filed again. It depends on how the acquisition happened. If the new company is taking all the responsibilities for the POM labor, we call it as a successor of interest. If the new company meets the requirement, you don't need to file POM application again. You can file the, you just need to file an I-140. If they don't meet the successor of interest, then you have to file the POM and I-140 again. Vanilla has this interesting question. If all the people who are in EB2 start converting into EB3 and filing an adjustment of status application, can I still file adjustment of status if my priority date becomes current? Vanilla, once your priority date becomes current, it doesn't matter what other people's becomes current or not. You can file the adjustment of status immediately. You can do so. Later on, normally what happens is that the priority date becomes current. It may backlog a little bit afterwards. It happens. I mean, in 2012, the priority date was, in March of 2012, the priority date was May 1st of 2010. And from then onwards, it only backlogged. It never went forward for EB2. Yes, if you see a lot of people downgrading from EB2 to EB3, there is a definitely good chance that EB3 might backlog more. But at the time once it moves, you file, you are in a safe boat. In other words, you can cruise through, you shouldn't have much problem at all. You will be in the adjustment of status. Another follow-up thing in this is that for those people who are downgrading for EB2 to EB3, I do not recommend them to downgrade right now. What I recommend is to downgrade it when the priority date becomes current. Now people may ask, when you downgrade, do you need the EB3 I-140 approval to file the adjustment of status? No, you don't need the I-140 approval. All you need is the application I-140 pending. So what we normally do is we attach the I-140 to the 485 and then we file them together. I-140 downgrading, adjustment of status. It goes in one FedEx envelope and then we file it with the USCIS. We do that very often and we don't have any problem whatsoever at all as of now. We've been doing it whenever, because this habit came actually from Chinese nationals, because for Chinese nationals, EB3 was more moving forward than EB2. So we started doing conversion from Chinese nationals, and then later on in the past 1 year, 1.5 years, we started doing for Indian nationals because EB3 is more advanced for Indian nationals. Yes, I want you guys, whoever is considering EB2, EB3, I want you to read, I want you to study the video that we posted exclusively on how to downgrade from EB2 to EB3 and what are the consequences, what steps you need to do. Please watch that video.
Arihant from Facebook says he got his H-1B status last year and is asking, could he visit India now for stamping? Is it safe? So we have discussed consular availability, different options like the Dropbox, possible emergency or expedited appointments. Those are all, I would say, cases when getting a visa stamp at the consulate is necessary and unavoidable. If there is emergency travel for a very urgent reason, if there's a maintenance of status issue in the US that requires you to leave the country and to get a visa stamp before you return, if you're outside the US and had the petition approved and this is your first time needing the visa stamp to come into the US, those are all situations to look at an emergency appointment, exceptions to the presidential proclamation, those sorts of things. If you are in the US right now in valid H-1B status and you do not need to leave the US for an urgent reason, I would say that you shouldn't leave the US. Once you leave the US, if you are not eligible for the Dropbox, which it sounds like Arihant probably is not, because it sounds like this is his first time getting an H-1B visa, so you would not be eligible for the Dropbox. Getting an in-person visa interview sounds very difficult. Like we said at the top, especially in India, appointments aren't opening up. Regular appointments are opening up only in February 2021 at the earliest. That can always change. Like I said, we've had clients schedule and secure an interview date at other consulates in other countries only to have them canceled and rescheduled repeatedly, like 3 times for one of my clients. So I would not choose this time to leave the country and get an H-1B visa stamp, given all the uncertainties with consular visa appointments.
Chetan has this question. He has an O1 petition approved, but his EB1A is denied. Does refiling same petition, it goes to a different officer, is a better option? Chetan, I would suggest 2 options for you actually to do at the same time. Refile it and sue the USCIS, both. Now, what happens is that typically when we sue the USCIS, the next application that you file will be approved, and they will come back to us saying, hey, withdraw the withdraw the litigation. We do that now. Having said that, past performance is not an indication that every case will go through the same way, but I'm just telling that suing the USCIS and filing an application at the same time would be a better option for you.
Imran from Facebook says that his H-1 is going to expire in November, but his perm was only filed a couple months ago in July. So Imran, if November is the expiration date of your 6-year H-1B limit, that is going to be pretty problematic. There aren't that many options for you since, as you said, perm processing is taking 4 to 5 months. It's not that likely that it's possible, but it's cutting it very close to get your labor approved and the I-140 approved before your 6-year limit is up. I would definitely discuss with your attorney and company for backup options to see if you have any time spent outside the country since you first started H-1B status that you could possibly recapture. Your company would need to be able to be willing to cooperate by filing an extension for a possibly short period of time just to buy you that extra time until your I-140 can get approved. That's one option. Changing to another status is another less good option since it takes so long to change status and to change back. Waiting outside the country is sort of the last resort, but because it is coming up soon, I would definitely speak with an attorney to nail down exactly when your 6-year limit expires and see what options you have.
Gajanan Deshmukh from YouTube has this question: is maintaining the non-immigrant status necessary once we file the 485? No, Gajanan, it's not necessary that you have to maintain the non-immigrant status. We normally don't recommend maintaining, but some of the lawyers do recommend. But our office, unless there is some underlying problem with your I-140 or something like that, we do not recommend maintaining the non-immigrant status. Though it's like, you know, buying 2 tickets going on the same plane. You know, why do you need it? If the plane fails, well, you know, everything fails anyway. So but there are some exceptions that are available where it may be advantage to maintain the non-immigrant status. But a lot of times it's more disadvantage though. Krishna from YouTube, he got laid off on H-1B. He's in the 60-day grace period. Can he go for Mexico for H-4 stamping? Well, right now the U.S. consulates in Mexico are not open for the H-4 stamping. So they are open for some emergency appointments, and I don't think so they're open for the third country nationals for H-4 stamping right now. So the better option for you, Krishna, is to file a change of status application while you are in the United States. In this COVID pandemic situation, since you have the option of filing within the United States, don't. And if they give an appointment though, I'm not telling that if the US consulates in Mexico does give an appointment to you, yeah, you can go for H-4 stamping. Absolutely, that's not a problem. But if they don't, I want you to take the option of filing H-4.
Upender from Facebook says that he is with a certain employer. His green card, I assume the I-140 was approved with a previous employer, and if his priority date becomes current, can he file his I-485 with employer A while still working with employer B? It really depends on employer A. So they are going to need to be willing to sign an I-485 Supplement J that states that they still have this I-140 position open for you and that they intend to employ you in that position permanently once your green card is approved. So first of all, that depends on your relationship with company A. If they're willing to sign that, they need to be willing to basically state that to the government to attest that they do have this position open for you and that you will be filling it once you are a permanent resident. Technically, if they are willing to do that, then yes, you can file the I-485. I would be very careful though and check with your attorney.
The consulate open, that's a question some person is asking there. Their consulates do a lot of different functions, guys. One of the function is, of course, visa processing. They do have other functions too. For the visa processing, they practically are closed except for emergencies right now. They are doing the Dropbox though. In India, they are processing the Dropbox. But as such, the general consular appointments all over the world right now are practically not open except for emergencies.
Rajesh is asking what happens when you have filed an H-1B change of status, a change of status to B2 from H1 or H4, and then you leave the U.S. before the application is approved, or before, I think we had an earlier question that was similar. What if you leave the country while the B2 application is pending before biometrics are taken? So departing the U.S. before biometrics are taken, before the B2 change of status is approved, are fine. You're not required to stay in the U.S. waiting for the outcome of the I-539 application. It's going to take several months, probably more than 6 months. And the whole point of the B2 filing is to state that you don't intend to stay long-term in the U.S. You're just asking for some additional time because your intention is to depart. You're just trying to wait until it is safe to do so, health-wise, or until flights are available. So once you are able physically to depart the country, you should, even if the B2 application is pending. You won't be considered to be unlawfully present during the time that the B2 application is pending. You have the receipt notice of the I-539 application showing that it was filed while you were still in status, or during that time, that while it was pending, you were in a period of authorized stay. And that remains. That doesn't change even if you depart the U.S. Just hang on to that receipt notice, and it's fine for you to withdraw the application once you leave.
Rebecca, this question is for you. And if my work location is Dallas, Texas, because of the COVID situation, I'm now working in Houston, Texas, not Dallas, Texas, which is almost like 250 miles from Dallas, Texas. Do I need to file an amendment because of the COVID? Am I not exempt? Do I need to file an amendment?
Yes. So if your approved H-1B and LCA are for Dallas and you are working remotely from Houston, your company should have or needs to file an amendment application for you as soon as possible, because that change in physical work location for you is outside of the metropolitan statistical area. So if you were working remotely in the Dallas area, in the DFW area, there would be no change needed, even if you...
So if my home is in Irving, which is in the Dallas area, I don't need an amendment. But if it's in Austin or Houston or any other city outside the Dallas metropolitan, there's a metropolitan. A lot of people are under the assumption that you can work from home. No, that's not. As I was telling before, the governments at this point of time don't recognize cyberspace as a space, guys. They only recognize where your butt sits. Since your butt is sitting in Houston, you don't have an LCA there, you are violating the law. That's what they are telling. So please make sure that your employers correct their LCAs and have their amendments certified, have their amendments filed. Otherwise, you'll be in trouble. Anything else, Rebecca? It's time now?
No, that's all.
Thank you, Rebecca, for coming in. Thank you, everybody, for tuning in. Don't forget that you can make an appointment with Rebecca or me at any point of time. It's available at rahul@rnlawgroup.com. We do have a daily conference call. If you want the details, you can go to RN Law Group. We do every day for half an hour. We do present. You can ask the questions there. From every day at 11 o'clock, we do have H4EAD delays conference call from 11 o'clock onwards to 11:30. That's there every day. We have a conference call. So you can make an appointment with us. You can subscribe to our news section and keep coming so that we update you about what's going on in immigration.
Thank you.
Thank you, Rebecca.